Second case on this morning's docket, case number 109044, State v. McClelland.
May it please the court, Peter Meharry for defendant Tyree McClelland. I would request 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. In this case, Mr. McClelland was charged and convicted of felony murder. He was also convicted of 3 counts of attempted egg robbery and egg burglary. He was sentenced to 20 years for the felony murder, 20 to life, along with 153 months for the on-grid crimes. In our brief, we raised 3 issues, one of which is a sentencing issue. I believe the state's conceded that. Unless this court has questions about the sentencing issue, I'll just focus my arguments on the first 2 issues in the brief. First issue that we have raised is an alternative means argument. It is our position that the jury was presented with 3 alternative means to convict on the felony murder charge. Specifically, the underlying felony, or I should say the options for the underlying felony for the felony murder were 3 counts, 3 separate counts of attempted egg robbery. The attempted egg robbery of Mr. Leilai, Mr. Penry, and then also Mr. Jones, the deceased. Our argument is that there was insufficient evidence to support one of those alternative means, namely the attempted egg robbery of Mr. Leilai. The attempted egg robbery of Mr. Leilai was completed prior to the killing of Mr. Stone. So we do not believe that that can form a basis for the felony murder charge. As we all know, felony murder requires the killing to be done in the commission of, or attempt to commit, or flight from an inherently dangerous felony. In this case, given that Mr. Leilai had escaped, was out of any danger, only returned to the scene on his own accord, given that he had taken those actions and that had been done, we believe that the attempt to rob Mr. Leilai was in fact complete and cannot support the felony murder charge.
And what is the strongest case you are telling us that you have to support that point?
That the felony was complete?
Yes.
We believe that because he was outside, he had escaped. Mr. McClelland entered the house, pointed a gun at Mr. Leilai, demanded...
I understand your argument. I'm just trying to find out the best legal basis you have to support the argument. Is there a particular case that you can point us to that says, yes, this absolutely proves my point, or this is close to proving my point?
I don't know that there's a specific case that I would point to. I know the state points to, I believe it's Casante, that's how you say it, where they said that the felony was not completed, it was in the course of the felony, so the felony murder was proper. But I think there's a distinct distinction between that case and this case, in that in this case, Mr. Leilai was free and clear. He had left the house. Mr. McClelland was not chasing him. He was outside of any danger. He went to his neighbors, where he then came back with some friends, but he was free of the attempted robbery. So the attempted robbery was in fact, for lack of a better term, completed when he left the house. So we think when you look at what is involved in an attempted robbery, the attempt to take property from the person, that had been done, and that had failed because Mr. Leilai had escaped and ran to his neighbors. So it's our position that when you look at the elements of attempted robbery and the facts of this case, it is in fact done prior to the shooting that resulted in the felony murder charge.
Counsel, you have phrased this as an alternative means argument. Is it really more of a multiple acts argument? That there were three potential or multiple acts that would have supported the conviction?
I think this is an alternative means because when you look at alternative means versus multiple acts, you have 3 distinct acts that can form the crime. My understanding is it's alternative means when you have essentially alternative means to support an essential element of the crime. In this case, I don't believe that there's multiple acts because there's only one death. there's only one felony murder. My understanding of multiple acts is that, and we see this often.
Well, but the underlying, there are multiple acts that create the underlying felony.
There are, the way the court has been using vernacular, I would call them alternative means. Because I think multiple acts imply something different than what we have here, in that multiple acts can lead to multiple charges. If this is a multiple acts case, I think you would have to be able to say that there are multiple felony murder charges that could be brought, and I don't think that's the case. So I think this
It's multiple acts as to the attempted aggravated robberies, but not as to the felony murder. The felonies are the alternative means for the felony murder.
I mean, there are multiple acts here that did support 3 charges of attempted aggravated robbery.
It just happens they're all the same crime. Sometimes when you have a felony murder, the alternative means for the felony murder are 2 different crimes.
Yeah, you could have a kidnapping or a robbery. Here we have 3 attempted egg robberies. So I think this is an alternative means because the essential element of the underlying felony could be one of these 3 charged felonies. So I think in that sense it is an alternative means as I interpret the case law that this court has handed down over the years. And when you have an alternative means case, we have what's been dubbed a super sufficiency test requiring substantial evidence to support each alternative means. And as I've stated before, our position is that there is not sufficient evidence to support one of those alternative means, specifically the attempted egg robbery of Mr. Lei Lai.
And your best argument that this doesn't fit within our time, distance, and causal relationship that is pretty broad in these cases, if you look at the cases at our prior case law, is that Mr. Lei Lai, as he was attempted to be robbed, and then 2 of the people then attacked Mr. McClellan, he left and came back, got help, doesn't fit within that time, distance, and causal relationship.
No, I think the fact that he escaped is a break. I think it's I don't know if this is the right term, but an intervening cause if you're in another type of case.
Depends on your opinion of what escape is when he goes next door, comes right back. But I understand that.
Yeah, the escape is that it was his choice to come back. He was free. He could have stayed at the neighbors. He could have kept running. More power to him that he came back and helped his friends. But he did that on his own accord. So I think that is a break in the attempted robbery of Mr. Lei Lai, such that it cannot support the felony murder. If there are no other questions on that.
When he got back, though, he was still in the process of robbing the other 2, or attempting to.
He was still in the process. What the evidence was that they were struggling, fighting over the gun. And our argument is not that the other alternative means are insufficient. Our argument is focused on the alternative means with regard to the attempted robbery of Mr. Lei Lai. If there are no other questions, I would like to at least touch on the second issue in the brief, and that is dealing with the complaint versus the jury instructions. And it's our position in this case, the jury instructions allowed for the jury to convict on what essentially is uncharged conduct. The complaint in this case, when it charged Mr. McClellan with felony murder, charged him with the killing of Mr. Stone, and identified the underlying felony as simply generically attempted egg robbery. You move to the instructions. The instructions spell out that the attempted egg robbery was of one of the 3 victims in this case. It's our position that the complaint is then insufficient. The jury instructions allow the jury to convict on something that is not spelled out in the complaint.
But based on your first issue, you're saying it didn't allow the jury to convict based on one egg robbery. The state had to prove all 3 of them.
Our first argument is that there is insufficient evidence for that.
And so it's sort of ironic that this is not so much broader, but it's more onerous on the state to have included all 3 if we apply the alternative means analysis to it. Because then it required the state, if they're gonna put all three, they have to put on evidence all three.
That is correct. But I don't know if I would say that's more onerous on the state. I would say that almost gives the state flexibility that they aren't essentially tied to their complaint, because complaint is in generic terms, whereas at trial, then they can, I guess, pick and choose. So it's that problem where you have a disconnect between the complaint and the jury instructions that we think fails to give proper notice and fails to properly apprise Mr. McClellan what he was facing at trial. Because of that, we believe that that warrants reversal in this case. If there are no other questions?
And there wasn't objection, so we're clearly erroneous.
That is correct. There was no objection to the jury instruction as to the felony murder charge, so that we are under the clearly erroneous standard, Your Honor.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Good morning. The state appears by Assistant District Attorney Jody Litvin, and may it please the court. I'll begin with the first issue on the sufficiency. It's the state's position here that if we look at the case law that has talked about felony murder, the res justi kind of analysis that we have to do, or that this court has done, that there was sufficient evidence here of the attempted aggravated robbery of the homeowner here, I'm just going to refer to it as David. The the attempted ag robbery of David happened first, and then the other two men caught Mr. McClellan's attention. I think there is some dispute about when the actual shots occurred. There is testimony about when the shots occurred as David was running out of the house, and when David got over to the other neighbor's house, Mr. Ford and Mr. Fonseca, he had said they shot him or he's been shot. So I think that puts this case within the res justi of the underlying felony there, if we take that testimony into consideration as well, not only David's testimony that he heard the shots after he was running back to the house from his neighbors. That puts it even more closely in time, and if we look at distance, it all happened within the same house, in the same room, the living room / dining room area. So I think that given the other cases that this court has looked at for felony murder, and the res justi analysis, that this court can clearly conclude that there was sufficient evidence here in these circumstances. And then as to the broadening of the complaint, the state's position here is that the crime that was charged, the felony murder crime, listed the exact elements that were included in the jury instruction and did not broaden the complaint. If this court finds for some reason that it was broadened, we would argue that he's not prejudiced here because he was given notice of the felony murder of the 3 separate attempted aggravated robbery charges within the complaint, listing all of the separate victims. From preliminary hearing testimony, the defendant understood that there was the attempted aggravated robbery of the homeowner and of Mr. Stone and of Mr. Penry. It was never raised below that the state hadn't picked what underlying felony. There was no confusion about the underlying felony, and he simply can't prove prejudice even if it was broadened. And I don't believe I have any other evidence. I would just submit the third issue on the brief.
Well,
You do concede that,
right? Yes.
All right. Any further questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
I would waive unless there are questions from the court.
Any questions? I see none. Thank you, counsel. I thank you both for your arguments this morning. The court will take this matter under advisement.